how the 11th Circuit Court of Appeal case with Ira Kleiman and Wright could affect the Copa v. Wright trial and the ultimate identity of the Bitcoin origins creator, Satoshi Nakamoto. So it looks like yesterday, a case, the 11th Circuit Court of Appeal, which is over Florida, just came out with this decision in the Ira Kleiman versus Wright hearing from 2021, the trial versus 2021. And let me just do a quick recap on what happened here. Basically, the case involved a dispute over the origins of Bitcoin between the estate of Dave Kleiman and Craig Wright. The estate claimed that Kleiman and Wright formed a partnership to develop Bitcoin and mine Bitcoin. A jury found no partnership existed between Kleiman and Wright. So then the estate, Kleiman, appealed on 3 grounds. First, the jury instructions on the partnership formation did not accurately reflect Florida partnership law. The court rejected this, finding that the instructions properly stated the law requiring certain factors to prove partnership. Second, the district court improperly vacated sanctions a magistrate judge imposed that would have deemed certain facts true related to the partnership. The appeals court found the district court did not abuse its discretion in vacating those sanctions. So that what happened there was that Wright was sanctioned. The appellate court reversed those sanctions earlier on in the case. And then here we are in the appeals, on the appeal of the actual trial itself. And they're saying the court shouldn't have reversed those sanctions. The appellate court saying no. The court didn't abuse its discretion in vacating those sanctions. The district court should have granted a new trial to opposing counsel's violation of an order prohibiting evidence about the sibling relationship between Dave Kleiman and the estate's representative Ira Kleiman. In that matter, there were some things that were brought before the jury where Dave Kleiman wasn't visited by his brother Ira Kleiman in the hospital, and the only time they saw each other was 2009 and Thanksgiving. And there were some objections back and forth about, that's really that could cause prejudice with the jury. The fact that Ira Kleiman didn't visit his brother while he was in the hospital for all those years. The appeals court found the district court did not abuse its discretion in denying a new trial. So, in summary, the appeals court affirmed the district court's judgment, finding no partnership existed between Kleiman and Wright during the development of Bitcoin. So, ultimately, the reason this is significant is because now it's a published case in the 11th Circuit that can be cited in the January trial, holding that there was no other party involved in the creation of Bitcoin. There was no partnership. I mean, this is significant. Now, granted, it looks like Wright, he got lucky on some of this because it notably absent from the estate's briefing was any case law that supports its position. This is on the first grounds. And then also the estate cites one case, but it was silent, cites one case, but is otherwise silent about issues here. So in addition, it didn't, the court's appeal here, it's saying it didn't follow the proper appeal standards and specifically referencing what it was appealing on specific grounds. So there were some procedural errors on the appeal by the, looks like by the Ira Kleiman attorneys. So without going into the complexities of this opinion, it's pretty extensive on some of these pages and arguing, bringing up the common law in Florida, how there's a precedent there that has to be followed. But what it's saying here basically is that the estate bore the burden of establishing the formation of a partnership by a preponderance of evidence. Plaintiff's burden to prove is that a preponderance of evidence or greater weight of the evidence and the application of a rebuttable presumption is not inconsistent with requiring a jury to apply the 4 partnership factors listed above in the decision, since it's up to the jury to determine whether or not such presumption has been rebutted. So it's absent the the appeal was absent of any case law. It was absent of any authority, and it just didn't meet the rebuttal presumption there was a partnership existed. So ultimately, the court's finding there was no partnership, meaning that there was just one person that created Bitcoin. This is now the law inside this case, and it can be cited. It probably will be cited in that UK case, because now it's a published opinion in the 11th Circuit. So this is now public law that can be cited, and it's going to be. Don't think for a second they're not going to use this. This is really, really interesting news. I mean, it's very, very exciting and interesting news to see how it plays out. Without a doubt, Wright is going to be in the media. He's going to be in the news, over the next few months. So people are going to be. It would be great to get a media pass there. I would love to do that. Or be able to go to that trial in person. Something I would, really enjoy doing. I went to the Kerry Lake trial, sat in there. That was last year. That was really cool. But this would be really fun to be at, even if it's just a member of the public. But it would be cool to be at, just as to say I was there, or as a media pass to report on it. It'd be awesome. So anyways, if you like this, like, comment, subscribe, leave a comment below, hit the notification bells. I'm going to put a hand cash in here so that I could I'll put a hand cash link in here as well. So people who have Bitcoin, they can send Bitcoin out and start doing a fund for me to go to this trial. That'd be freaking cool, and support the cause. All right. This is Gavin, Mehl. Like, comment, and subscribe. We'll see you next time.